rise. The Court of Appeals, Division 1 is now in session.
Good morning. Please be seated. This is the time set for oral argument in Stephanie Fisher versus USAA Casualty Insurance Company, CA-CV170589. Out of respect for counsel in the court, I ask that those in attendance please make sure that cell phones are off or in vibrate mode. Each side is allocated 20 minutes for argument. Appellant, you may reserve a portion of that time for rebuttal if you wish to do so, but you will need to keep track of the time using the podium clock. We don't do it for you. Both counsel, we have read the briefs. We have conferenced the case this morning, and we are very familiar with the record. We encourage you to keep that in mind when you make your arguments. These proceedings are being recorded and will be posted to YouTube. So before you begin your argument, please state your name and the party you represent so that people watching online can figure out who you represent. With that, counsel for appellant, you may proceed. Bless you.
Good morning. My name is Jared Olson. I represent Stephanie Fisher in the appellant in this matter. And if it please the panel, we are here seeking a review and a reversal of the decision of the Superior Court denying our motion to vacate arbitration, as well as the decision denying our request for discovery into the potential partiality and bias of an arbitrator. As the court has stated, they've already read the briefs and they're familiar with the records, so I won't go into too much detail. But I would like to preface this by stating that we are not asking the court to reopen the facts and law determinations of the arbitration. We're not asking the court to reopen and review carte blanche what the arbitrator did in the arbitration. We are focused solely on the issue of partiality and bias.
Well, what's the effect of the relief you're asking for then?
The effect of the relief we're asking for is that the court, at minimum, allow us to conduct limited discovery into the ongoing relationship between the arbitrator and Jones, Skelton, Hockley, the law firm that represented USAA, the appellees in the arbitration. And if that discovery discloses and determines that there was a partiality, evident partiality as the law requires, then that would be grounds for the court to vacate the arbitration.
Do you have any cases that suggest that assuming the allegations or the things you're interested in bear fruit, any case that suggests the fact that an arbitrator may have done a lot of work with respect to not one of the parties, but a law firm for one of the parties, that would demonstrate sufficient partiality to merit relief?
We do have a case cited in our opening brief, Wages v. Smith, Barney, Harris. In that case, the Court of Appeals said it was good grounds to vacate it for an undisclosed relationship, or even in a relationship that creates the impression of bias. Therefore, it doesn't actually need the full requirement of bias. However, the statute itself, ARS 12-3011 and 12-3012, require the arbitrator to disclose and in some cases recuse themselves if there is an existing relationship with the party or their legal counsel that is substantial as well. And that is what we're worried about today.
What information did you have after the arbitration that you did not have, or did your client have after the arbitration that you didn't know before the arbitration? It seems to me the record seems to suggest that before the arbitration, your client was aware that this arbitrator had acted as an arbitrator in cases in which this attorney and the other side was involved. So if you already knew that at that point, what is it that changed other than the result of the arbitration proceeding?
Well, to be completely clear, the Fishers prior to the arbitration, even during the arbitration, did not know that this. All that they knew was that about a day before the arbitration, their attorney came to them and said, "You should probably settle because I believe that this arbitrator does business a lot with Jones Skelton Hockley, and you may not get a fair shake if you don't settle now." Going into the arbitration, that's all of the Fishers knew. They did not know what the motivation.
I read the statement from the attorney as saying, we work with this arbitrator, or we have cases that he handles. Jones Skelton has cases that they handle, but they're a bigger firm than we are, so they probably have more cases. But doesn't that put your client on notice that this particular arbitrator has handled cases in which USAA has been involved, or the attorneys from Jones Skelton have been involved?
Well, as the trial court pointed out in oral argument and the questioning on the issue of the discovery motion, all we had at that time was a hearsay statement from attorney counsel. That wasn't credible or direct evidence on this, and that is the main reason why both in the arbitration proceedings and in the lower court we asked to do discovery, because we wanted to determine if there was merit to that claim by the Fishers counsel. And again,
But you have the same information then that you do now, right? You don't have anything new since then. So why didn't you request this discovery? And I realize it was different counsel at the time.
correct.
Why didn't you request the discovery before the arbitration? Why did you wait till afterwards?
Well, and as you said, our firm did not represent them, and we may have done things differently in hindsight being 2020. But the reality is that at the time of the arbitration, the Fishers didn't know whether they could give credence to that statement of their counsel, and frankly, under the statutes, ARS 12, 3011, and 3012, the arbitrator has an affirmative duty to disclose. And I think the main issue that we saw in the lower court and in the arguments by appellees in this brief is that it seems to be trying to shift the burden from one of affirmative disclosure by the arbitrator to one of making it that the appellants then are required to actually dig deep into what the arbitrators do and don't do. And frankly speaking, given the nature of this relationship, if the arbitrator doesn't disclose and tell us, I've done so many cases with this law firm, or I make so much money from this law firm, there's absolutely no other way short of actual discovery that we can find that information out. We can't go online to look up. There is no public record repository. We have to find out from the arbitrator or from Jones Skelton Hockley what the relationship is, and there's no other way to go about doing that.
So carrying your point to perhaps an extreme, let's assume that the Fishers were advised that because of the exchange of information among the plaintiff's bar, that there was evidence that this arbitrator had sat as the arbitrator in 15 prior USAA cases, that Jones Skelton Hockley was involved in each and every one of them, and that the arbitrator had ruled in the insurer's favor in every case. But you argue that you suggest that type of knowledge is almost irrelevant, that the obligation is on the arbitrator to affirmatively disclose that relationship. And if he doesn't, your clients don't have to do anything until after an adverse award is received.
With respect, Your Honor, what we're saying is that we can't relieve the arbitrator of his duty to tell us that, yes, I've done 15 cases with Jones Skelton Hockley. And that is information that, as parties to this arbitration, the Fishers were entitled to have in order to make the decision of whether to actually go forward with the arbitration. And, I mean, the law is pretty clear that as far as waiver goes, a person cannot waive a legal right without actually knowing that they're doing so. And at the time of the arbitration, we really didn't have knowledge.
You passed that off as just a hearsay statement. This is your own attorney telling you that this arbitrator has acted as an arbitrator for these people, for this party, and has worked on cases in which Jones Skelton has been involved. Why is it just hearsay that's not, I mean, how is that not direct knowledge? There's at least one case, or there's at least, presumably, at least two or three. Why isn't that enough to trigger? How can we just say that's just some kind of hearsay statement that we're not entitled to rely on? Particularly in the context of this is the arbitrator that your clients have requested through counsel. We assume counsel and clients are acting in concert.
Well, Your Honor, it is true that we indicate our clients, the Fishers, did request, or they designated they were willing to work with this arbitrator before they knew about any potential
And not
relationships.
just indicated they're
bias.
willing,
Yes.
they actually suggested that this arbitrator be used. Is that right?
Correct, without any knowledge of the arbitrator's prior existing knowledge. And at that time, it was the duty of the arbitrator to tell all the parties, well, I've worked with your parties, or I've worked with your attorneys in the past, or here's what I get my business. Especially, I mean, in this day and age when there are people who do arbitration all day, every day for a living, that is their entire source of business, that only amplifies the financial impetus for repeat business.
Isn't that, though, kind of, you keep saying work with, but work with maybe has a different connotation in my mind than what I think you're trying to say. He wasn't a partner with, or even under your allegations, there's no, outside of the relationship of being hired by them to do arbitration, there's no other existing business relationship, profit incentive. It's just his work. It would be like saying, and then if that's true, then I don't see why it would be different if it's one prior case or 15 prior cases. Where's this line that you think that at some point the arbitrator has a duty to disclose, hey, you should know I've done 6 prior cases with USAA, or 12 prior cases, or where is that number?
Well, frankly, Your Honor, for the disclosure burden, I don't think there is a number. I think whether it's 1 case or 6 cases or 16 cases, the arbitrator should be upfront and tell the parties, here's what I've done with parties in the past. Like, I have worked with these attorneys in the past. Do you still want to use me as your arbitrator?
But he probably presumably had worked with Fisher's attorney, presumably in the past, since they indicated they're willing to work with him. So wouldn't he have had the same obligation to disclose to Jones Skelton or to USAA that?
Yes, Your Honor. I mean, and the point is that if the arbitrator had come forward before the arbitration and told him, I worked with Jones Skelton Hockey this many times, or I've made this much money from the USAA in the past year, and told the Fishers that before the arbitration and given them the chance to say, well, maybe we'll go with a different arbitrator, we would not be here today.
Okay. But you knew that he had worked with them in the past. You don't know how many, but you knew it was at least one.
What we knew is that, what the Fishers knew at the time is that their attorneys thought they should try to settle again. That their attorneys,
Because he
changed their
knew,
mind.
he told them that he had worked at least one prior case with Jones Skelton in the past.
Yes, Your Honor.
Didn't it
Okay,
even
so
go
then you
beyond
had
that?
all the information to raise the objection at the time.
Frankly, Your Honor, no, we didn't, because even after the arbitration, that the main reason we actually had to file the motion to vacate was because we were
You
seeking
just told me
information.
the burden applies even if it's just one prior business relationship.
The burden to disclose, yes, Your Honor.
Okay. And since you knew there was at least one, you were on notice that there was a potential conflict, and you could have raised the objection ahead of time.
And, Your Honor, I will not speak to what another attorney should or shouldn't have done during an arbitration, but the point that I believe needs to be made is that the Fishers at the time of the arbitration simply didn't have sufficient information. All they knew was that their attorneys said, I think the arbitrator has some nebulous, undefined relationship with Jones Skelton Hockey. They may have done one or more other arbitrations in the past.
Wasn't the suggestion that the arbitrator had worked on cases with that Jones Skelton had been involved, and there was a number of attorneys at Jones Skelton, so that it's likely that there were several cases, much more than the Fisher's previous attorney had been involved in. So wasn't it clear at that point? That's his reason suggesting that they settle. So that information, why isn't that information attributed to them? It's knowledge the attorney has and directly communicates to them.
The knowledge that was actually indicated was not actually clear. It wasn't specific. It simply said that there is a relationship there of some sort, and because of that, we think you should try to settle this before arbitration. And so going into this, it wasn't clear to the Fishers whether their attorneys were, frankly, whether their attorney was being genuine or whether their attorney wanted to forego arbitration, try to pressure them into a settlement. And it wasn't until later that after the arbitrator ignored multiple requests for information and discovery on this issue that the Fishers were left with no option but to file a motion to vacate with the court and therefore try to get discovery through court processes.
Something that necessarily has to be presented, that the Fishers have to know, or if the attorney is aware of it, and nevertheless requests that an arbitrator be used. Don't you have a different issue of, well, maybe the attorney should have talked about it more thoroughly with counsel, but in terms of disclosure, if one side turns over disclosure to an attorney and the attorney doesn't just walk through every detail in the disclosure, has there been a disclosure violation? If it's clear that the attorney is aware of the information, is there a disclosure problem?
If the information was actually disclosed to the Fisher's attorney and their attorney chose not to share that information, then yes, I would agree that would be a problem. I think that would be a major violation by the attorney. But it's also a matter of whether this information was actually disclosed, or whether the attorney had heard through the grapevine that this arbitrator may have worked with Joan Skelton Hockley in the past at some point, versus the arbitrator actually making a disclosure.
But if we're attributing knowledge that the attorney has to the counsel, why isn't whatever the attorney knew at that point, why wasn't that enough to file an objection prior to going forward?
Well, again, Your Honor, because even what the attorney knew wasn't really sufficient for a full objection. That's why we've been requested discovery, because we think that there is information out there that can be found, and we are very confident that when this information is looked at, it will show a relationship. But there is always the possibility that there may not have been an extensive relationship, at which point the court, if it grants the discovery, can then choose to affirm the award. What we're asking here is simply the chance to look, because all we've heard is that the Fisher's attorney said, we think there's a relationship there. We asked the arbitrator for information. The arbitrator ignored us. We asked the court to do some discovery, and at which point Joan Skelton Hockley's attorneys came up and said, well, we're not disputing that we've worked with this arbitrator in the past, but don't worry about it. Just take our word for it that, it's not that bad, or it's not that many times. Like, there's something going on, and we believe that the Fishers have a right to at least determine the extent of this. If discovery is allowed and it turns out that there is not an extensive a relationship, or there is no evident partiality or bias, then justice has been served and there is no real prejudice in the court affirming the award.
Let's say there are 50 cases in which the arbitrator has served in a case in which Joan Skelton has been counsel. Does that mean we set aside the arbitration award?
I believe that at that point, once there is evidence showing those 50 cases, then that will be an issue that the court can decide with the actual evidence. But the issue is that in this case, the court didn't decide on any evidence. The court denied the motion to vacate simply because there was no, quote, specific evidence.
But if there's 10 cases and they rule in favor of Joan Skelton clients 90% of the time, I'm just trying to figure out at what point is there, when you know that Joan Skelton has been involved with this arbitrator before, is there some magic number? If it's just one time, that's different than 5, that's different than 10?
Well, in my review of the cases, I haven't seen there's no specific number. But again, going back to the wages case we cited, the linchpin issue is whether the record makes an impression of bias, whether viewed as a whole, the past decisions or ongoing relationship that was not disclosed creates the impression of bias. That is sufficient grounds to vacate.
In that case, there's absolutely nothing other than just the number of times served as an arbitrator. Because in looking at had just looked at the case you cited in your reply, Colorado case, was one where the arbitrator had been hired as a consultant. I think in the United States Supreme Court case, the Commonwealth case, the same point, the arbitrator had a separate relationship in addition to having been an arbitrator. Are there other cases other than the one you've just cited where it's clear that it's just the fact of having been an arbitrator?
I would have to defer to the cases in our brief. I believe that there was one in there. I would have to look through that for you, Your Honor. But I believe it's simply a test that the court must look at as a whole. When there actually is the evidence there about what's going on or what relationships there are, the court must take a view on a case-by-case basis. Since it's not well established, I think, in Arizona yet.
If it's just acting as an arbitrator and you serve as an arbitrator in 100 cases, doesn't that suggest that it's less likely that there's a bias? You would think if someone's an arbitrator 100 times, word would get out that this guy always rules in favor of one side or the other. It seems a little counterintuitive to me to suggest that just the sheer number of times that someone has been an arbitrator is going to evidence bias.
But the number of times that an arbitrator works specifically with one party over and over again can be an indicator that they're a repeat customer or they get a fair share of their business from this law firm, which creates a financial impetus.
But don't both sides have to agree to the arbitrator?
They do, and they have to agree.
Well, then who would we impute the conflict to?
That is why there must be disclosures, Your Honor, because it is up to the parties that once they know about the arbitrator's record and who the arbitrator works with, then the parties can decide whether they want to move forward with that arbitrator. The Fishers were not given one.
Okay, so because Joan Skelton selected them, and I'm saying, let's say in 10 prior cases, the arbitrator would have to say, I've been used 10 times by Joan Skelton and 10 times by whoever the plaintiff's side was, because the plaintiff's side also approved them. They'd have to give you a list of everybody that's appeared in every one of their cases previously. It wouldn't just be the Joan Skelton bias. You'd also want to know about who they represent on the other side as well.
I believe at a minimum that they should be telling you that I've worked with these parties so many times in the past, or at least a rough number, or I derived so much money I've gotten paid by them for arbitrations in the past. The main issue is that in order to actually make a decision to select an arbitrator and actually be able to make any kind of objection, the Fishers needed information, and they simply weren't given it.
All right, thank you very much.
Thank you, Your Honor.
May it please the Court, my name is Tim Highland. I represent USAA Casualty Insurance Company. As the Court's already read the record, I'd like to just try to address some of the issues that I heard the Court ask about. First off, Judge Winthrop, this really is an attempt to simply get a new arbitration. The fact of the matter is they're moving to vacate. They want it thrown out. They want to get a do-over. And the whole reason that they're doing it is because they have no other basis. They filed a motion for reconsideration in front of the arbitrator. He denied it. They could have gone up on the facts. They don't. All it is an attempt that if we don't have the grounds to do it, we make an allegation at the arbitrator. And that's all that's here. And in fact, if you look at the evidence that's here, they have none. As the Court has said over and over again in questioning, they recommended Mr. Goldman. Joan Skelton and Hockley agreed to that. So if they had an issue with vetting him, with asking him how many times he'd done it, they could have done it there. They could have done it the day before the arbitration. They could have done it at the arbitration. They could have done it at the close of the arbitration. They could have done it while waiting for the award. They could have done it after the award in a motion. But counsel filed a motion to reconsider. It was only later that the Fishers files a pro per second motion to vacate based on partiality. That causes the chain reaction. New counsel, prior counsel moving to withdraw in the separate litigation in Superior Court because of the fact they say they're being asked to do unethical conduct in the UIM proceeding involving lack of candor to the tribunal and lack of honesty to opposing or fairness to opposing counsel. What we have here is simply the fact that before this arbitration, Napier and Curry knew that they had recommended Mr. Goldman. Joan Skelton and Hockley agreed. They went in. They had a meeting with their clients before the arbitration. And as the affidavit says, they went over all the risks of going to arbitration. Doesn't say they came in and said, gee, you better settle because we think he's partial. They came in and said, we went through all the risks. One of the risks, they say, in their affidavit, which doesn't come in until late in the Superior Court proceeding, is we told them it was likely that the arbitrator had heard more cases than he had heard with our firm, admitting their firm they knew it had some, because Joan Skelton has more attorneys. Not that they knew he had, not that they checked, not that they had any concern with partiality, other than he'd had more cases. If that becomes the standard, then you're going to have Joan Skelton standing here saying, we want to do discovery because Snell and Wilmer's on the other side, and they have more attorneys than us. The fact here is there is no evidence at all anywhere in this record that there's any partiality, any relationship, any significant dealings. And the discovery that they want is not only untimely because they never raised the issue. They could have went in the day after the day of the arbitration and said, before we start, we'd like to know how many times have you had Joan Skelton on the other side or participate in front of you, or how many times have you had USAA as a party? And as the trial court said, she would have had a record. The arbitrator would have either said, declined to say, talked about what it was. But there's none of that. They go,
Why wouldn't we just kind of set forth a rule that says, arbitrators, you should give parties an idea of what they're going into? It would have been, I don't want to say easy, but relatively easy for the arbitrator to say, before we begin, just so you know, I've represented or I've worked in arbitrations involving the plaintiff's attorneys 7 times and Joan Skelton 25 times. Does anyone have any issue with that? And then move forward.
well, Your Honor, I guess if you want to make that to be the law, it means they have to keep certain records and disclose all that. But that's really on the parties, in my opinion, in vetting the arbitrator and who they agree to. And secondly, it's really irrelevant. As Judge Catani was talking, it's not simply the numbers. It's whether or not there's some relationship. And the wages case, Judge, that was recited to you with regard to the relationship, no. Mr. Warnock, the arbitrator they went after, what he didn't disclose in the Smith-Barney case was that he had had cases as counsel where he sued Shearson Lehman, the predecessor, on exactly the same facts, and that he had strong opinions regarding how they were supposed to handle disabled investors, and that he had previously alleged that they misrepresented with regard to a disabled investor that he represented. Those were the kind of facts that the wages court said showed evident partiality. The mere non-disclosure of the fact that he'd had cases with both parties.
In your view, is there then not an obligation to simply say, I have acted as an arbitrator in 50 cases in which Joan Skelton has been a party. I've acted in 10 in which the other side has been a party. Is that, in your view, is that not part of the arbitrator's obligation to disclose?
Yes, Your Honor, under the statute, I don't think that's the requirement for the arbitrator to disclose. The reason being it talks about a significant existing relationship. The fact that I operate as an arbitrator and people come to me every day and I arbitrate cases doesn't mean I have to keep track of every single one that they come in on. And remember, we're expanding this greatly. It's not whether or not it was that particular attorney at Joan Skelton. It's all Joan Skelton, or it's all Snell and Wilmer. It's not whether or not how many times Joan Skelton has represented USAA in front of him.
Oh, but how about if the discovery request is, I want to know how many times. Well, I guess you're saying it's the firm, but Joan Skelton has. I'm not asking for money. I just want to know how many times. Why is that an unreasonable request? Just to know, I'd just like to know how many times he's been involved and what the outcome of those arbitrations were.
Well, really, Your Honor, I think you're asking two questions. One is whether or not I think the statute requires the arbitrator to affirmatively do that. And I don't think so. I don't think that's a significant relationship that the statute talks about, that I operate as an arbitrator. Had they made that question, had they asked the arbitrator, can you provide me information on that, then I think the arbitrator probably should have responded and given the information.
So your view would be that an arbitrator's duty to disclose would be analogous to a trial judge's duty to disclose a relationship or partiality, as opposed to, which is based on a personal relationship, as opposed to the number of times a lawyer or a party has appeared in front of that judge in a case.
Your Honor, I think so, because the statute talks and asks for what a reasonable person would consider to affect impartiality, a financial or personal interest in the outcome, or an existing or past relationship with the parties, not simply acting as an arbitrator, which I do as plaintiff's counsel or appellant's counsel wished, a professional arbitrator. That's what he's done for the last 10 years. I don't think that establishes the type of relationship that the statute is requiring a disclosure for in order to show a lack of partiality. More than that, evident partiality, which they are arguing is a much higher standard, and we get nowhere close to that in this case. The nondisclosure simply of the number of cases I don't think is required by the statute. There's no evidence of any partiality. They didn't make the objection timely, which the statute requires them to do. The discovery request comes in way too late. The discovery request only comes in after my response when I said they have no evidence. Your Honor, even if you get to partiality, they have no evidence. Then here comes the discovery request for Jones Skelton, which is enormously broad. The court hasn't asked any questions about that, but it is huge. The discovery request in this case asked for not only how much money Jones Skelton had paid, but any of their insurance clients.
But that could be a different issue. If we're just,
it's a different issue.
We could say, are you entitled to some basic information? And if they, in your view, if they had made the request, then prior to the arbitration, that's something that should be disclosed. If the request is how many times have you acted as an arbitrator in a case involving this party?
If the parties have a concern regarding the number of times and they ask that, I think the arbitrator could say, I don't consider that a relationship, but yes, I can provide that information. Because again, the parties are agreeing to it. If the parties are saying, I plan to object unless you give me this information, I doubt any arbitrator is going to go forward with the party objecting to him. He's either going to provide it or say that I'm not going to do it.
But what is the process if a party just decides the day before the arbitration, I don't like this arbitrator, I don't want to go forward? Is there some reason the party can't withdraw from arbitration?
Not that I know, Your Honor. I mean, the parties could argue about it, that it had been agreed to. There might be cancellation costs of one to pay, but in my experience, at least, the parties going forward through arbitration jointly agree on the arbitrator. Because the court's read the briefs and know the facts here, I'm going to sit down unless there's any other questions regarding our position.
No, thank you, counsel.
Thank you.
All right. Thank you for your briefs and your presentations here today. We will take this matter under advisement. We will issue a written decision in due course. We will now be at recess. Or adjourn.